myself, the mayor, as chair. We have trustee Burgess, who will serve as the substitute village clerk. He is the second senior trustee. And we have Rosa Williams Day, who is the senior trustee. Trustee Burgess, please call roll.
Mayor Hanks.
Here.
Derek Burgess, here. Rosie Williams.
All right. Move to item number 3. We have the adoption of rules. And I ask the attorney, Luke Keller, to take it from here.
Thank you, Your Honor. At this time, we need a motion to adopt the rules of procedure. Just a little background, these are just standard rules that have been adopted by the Cook County Board of Elections, the Chicago Board of Elections, and the State Board of Elections. So at this time, to be proper, just have a motion to adopt said rules. Pardon? Yes.
I make a we have a motion. I will second. Trustee Burgess, please call roll.
Mayor Hanks.
Yes.
Trustee Williams Bay.
Yes.
Trustee Burgess, yes.
At this time, I'm just going to ask you to sign and execute a copy of each member to sign so we have an official. We've also give out copies to each of the parties.
All right, we have the call of the docket. We have Anderson versus Williams. Docket number is SVMOEB-01.
Okay, perfect. All right, first we're just going to have just an introduction of the parties. Maybe we can start with candidate.
Sure. My name is Ross Seckler, S-E-C-L-E-R, appearing on behalf of the candidate, Deborah Deputy Williams, who is present here
Okay, ma'am, can you just state your name for the record?
My name is Francine Anderson, and I filed an appearance to be pro-se.
Okay, and you are the objector, ma'am?
Yes, I am the
Okay, perfect. I believe we have an appearance for both Ms. Anderson and Mr. Seckler as well. Okay, thank you. Next, we're just going to have an introduction of the electoral board exhibits. I'm going to read them off. Exhibit A will be the objector's petition. Exhibit B will be the call. Exhibit C will be the nomination papers. Exhibit D will be the agenda. Exhibit E will be the service of the objections. And Exhibit F will be the rules of procedure. Do we have a motion to accept all the electoral board exhibits? Second. Please call roll.
Mayor Hanks.
Yes.
Trustee Williams Bay.
Yes.
Trustee Burgess, yes.
Okay, next on the, do you have any motions on behalf of the objector or the candidate?
He is, the candidate has prepared a motion to strike.
Just speaking of the microphone.
Oh, I apologize. We have prepared a motion to strike and dismiss the objector's petition, which we are prepared to file with the answer, as well as the notice of filing and service to state.
Okay, and you provided extra copies for the objector as well?
Yes.
Okay.
I didn't quite hear everything. You said you.
We prepared a motion to strike and dismiss the objector's petition, which we are prepared to file with the answer, We prepared, we have extra copies of the same, I can provide to the, a copy to the electoral board as well as one to the objector.
Okay.
Providing a copy to the objector now.
Yes. Okay, thank you. Okay, what I've been handed is candidate's motion to strike and dismiss objector petition. With regard to the objector, again, this is an expedited schedule, so normally give a couple days for the objector to respond. Would you like time to respond to the motion to strike and dismiss?
Yes, I do need time to respond.
Okay. Would Friday at noon be suffice?
Friday,
I think we at least need to get that within village hours, time frame, the hours, man, but with
what would be the problem with the time of our regular meeting?
yeah, this isn't for another meeting. This is just to file your, if you have a response. No, we will not have a meeting that day. Not right. This is just, you will be able to either fax it or email it to the, within the rules on the last page, there's an email address or a fax of the firm, which you would,
Friday at 5
okay.
p.m.
Does that work with,
No, we don't have an objection.
okay, will you guys need time to respond to that?
If we could have a brief period to file or live, it would be, even if it's Monday or Tuesday.
Okay.
Yeah.
We do it 20, could you turn it around by Saturday? Would you be able to do that?
Yeah. Yeah, no problem.
Okay. So we're going to have the candidate, why, 5 p.m. Friday. Excuse me, the objector. And the response, 5 p.m. on Saturday. Okay. Okay, so the response will be 5 p.m. Saturday. Okay, the only other thing we have, we do need to recess to a specific date and time. So originally, you have a motion?
Yes, sir.
Yes.
I have motions that I would like to bring. We have Rosie Williams recuse herself because she is the daughter of the candidate, and I don't think she can be fair and right. And this transaction of the electoral report, and that's going to be very closely. If not, I have a motion.
Did you the notice of motion, will you be finding that answer? Today, will you be finding that today? The motion? Do you have copies? Do you not have copies?
And I'm going to pay for that copy.
Let me see your.
This is the affidavit to bias and prejudice.
Motion.
Yes, we would like to be completed and respond to the next.
Okay, okay. Okay, I'll have to give you a copy of this, we'll have to make a copy of it. Yes, we'll have to make a copy for the board.
If it's easier to just email it after these proceedings today, that would be okay, but
My notarized copy is not emailable. You can check it without the notary. So the notary may be deleted. I can't hear you.
well, if that copy is scanned or emailed, perhaps we could.
Okay, we could scan email after this and get copies to
Either
the
way.
members as well as the candidates.
Thank you.
Oh, okay, so when we look like have to respond to that before Friday,
Probably Friday.
okay, in this section, we'll give you a Saturday at 5 p.m. to respond to that. Okay, originally had try to have the reconvene on Saturday morning at 9 a.m., but it looks like we're gonna have some overflow given the times to respond. Would Monday at the same time work for all parties so that we can meet?
Can we Tuesday? Tuesday at the same time? No, we don't.
Saturday night?
Saturday night? About midnight? That's inconvenient. How would you be Saturday night if you just responded? That's not convenient.
I think, Monday at 6. Does that work with the members of the board? So we're gonna have it at Monday at 6 o'clock.
I think the attorney for the candidate say that that's what I'm.
That would be fine.
So do I have a motion to recess until Monday? Monday, January 9th at 6 p.m.
Mayor Hanks,
Yes.
Trustee Williams Bay,
Yes.
Trustee Burgess, yes.
But they have that.
We're going to reconvene the case number SV-MOEB-01. Trustee Burgess, please call roll.
Mayor Hanks?
Here.
Trustee Williams Bay?
Here.
Trustee Burgess? Here.
Everyone to the attorney.
Good evening. The first order of business is the objector's motion to recuse Rosie Williams. We have received since then, on January 6th of 2016, we received a response to the motion to recuse from the candidate we have reviewed the motions and the motions to strike. And at this time, Mr. Chairman, I'd like to explain the law. There are only 3 statutory recognized reasons for that an appointed electoral board member should be disqualified pursuant to the election code. That's 10 ILCS 5/1-10.9. The 3 reasons are, number 1, if you're running for the same office. Number 2, if an electoral board member holds a pecuniary interest in the outcome. Black's Law Dictionary defines pecuniary interest as an interest which involves money, monetary, or something financial. It's been evaluated in the terms of money. The 3rd reason is that when a member of the electoral board will be required to serve as a necessary witness in the objection proceedings. Not one of these reasons exists in this manner. Statutory and case law provided for recusal if a board member has a pecuniary interest. There is no allegations of pecuniary interest or that have been met in this instance. Also, or if a board member is to be called as a witness in a relevant matter of the objections. The objection here solely relates in regards to Rosa Williams, relates solely to an alleged debt, which is not a legal basis for a challenge. A challenge to appear on the ballot. Therefore, there are no grounds to recuse anyone in this manner. Mr. Chairman, it would be proper at this time for a motion to deny the motion for recusal of Rosie Williams.
I ask for a motion to deny the recusal of Rosie Williams.
So,
I got a motion, is there a second? Second.
yes,
Trustee Burgess, please call roll.
Mayor Haynes,
Yes.
Trustee Williams Bay,
yes.
trustee Burgess, no.
Okay, motion carries.
The next order of business is the candidate's motion to strike and dismiss the objector's petition. Mr. Sinclair is here for the candidate. The candidate is pro se. It would be appropriate at this time for Mr. Seckler, to make an argument. And then after he's done with his argument, Ms. Anderson, you are welcome to respond. And Mr. Seckler will then respond to you.
Thank you. My name is Ross Seckler, S-E-C-L-E-R, appearing on behalf of the candidate who is also present here for this honorable board and this evening. The motion to strike and dismiss is relatively comprehensive, but there's some few things to point out and highlight for this board. In particular, and I think the key to focus on is that even if every single thing could be, that is alleged in the objector's petition, even if every single thing could be true, it does not amount to a valid objection to the candidate's nomination papers. It's that simple. The candidate, the objector relies on essentially an outdated form of the statute that's cited in her response in the objector's petition itself. The statute in question, 65 ILCS 5/3.1-10-5B, it's the part of the Illinois Municipal Code discussing an arrearage of a candidate being an arrears in the payment or indebtedness due to the municipality. The objector cites the Sincus case, it's an Illinois Supreme Court case, it's quite famous, but since that case, the law has changed, and specifically, the law has changed to say that now a person is not eligible to take the oath of office for municipal office if that person is at the time required for taking the oath of office in arrears. That means that the legislature specifically added that language at the time of taking the oath of office. So even if, and by no means, there's anything in the objector's petition, which if there's anything in there actually allege a debt or an arrearage in debt, or anything that's objectionable to the nomination papers of the candidate, the key is, even if that were all true, even if there was a debt, it's not an objection. That's really what I want to present and focus on today. The arrearage, and then we further, the candidate has submitted, cited a number of cases. In particular, there's some circuit court of Cook County, and this afternoon we sent courtesy copies via email. And I don't know, I have hard copies in case the board didn't fit them in time. The objector didn't fit them in time. But essentially, there's the case of Don Boone Biggs versus Municipal Officers Electoral Board, the town of Cicero, and the circuit court of Cook County. There was a far more egregious case of what was alleged and what was done, and the key to that, the holding in that case, is that mere speculation of a debt or something like, or just mere allegations, whether true or false, if a debt has not been adjudicated and judged, if it hasn't been assessed, and in particular, noting the language in arrears on a debt, you can't just, it's not just owing something, it's being in arrears, it's being past due. Not one thing in the objector's petition makes even the faintest allegation that there could be a real arrearage in debt. That this cannot proceed beyond this harassment act. Then very, very briefly, because these two issues have been so well settled, there's a lot of litigation in electoral board matters, and a lot of litigation for nomination papers, and a lot of different gray areas of the law, let's say. But these two issues raised by the objector's petition are so well settled that it just shows the frivolous nature of this objection. First, the name issue, talking about the candidate's name is being Deborah or Debbie or you, William, however the candidate's name is placed on her nomination papers. The statute is quite clear about how, in particular, 10 ILCS 5/10-5.1 talks about a candidate's designation of name. This isn't an issue where a candidate is using a political slogan like, Debbie lower taxes, Williams, or something like that. That's not what we have here. It's not what was alleged. That's the only basis for these kind of objections. There's an issue of title. It's a frivolous objection. It's not a non-objection. It should be stricken. Then the notary issue, we've provided a plethora of case law and electoral board decisions discussing issues of the alleged notary issue that was raised about notaries signing petition sheets as well. And this is a settled issue of law. As such, it should be stricken and dismissed. And overall, in the objector's response to this motion, at no point is there ever a scintilla of legal argument that even addresses the legal deficiencies in the objector's petition. This is completely frivolous. This is based on zero legal basis, and this matter should be dismissed with prejudice. And we have also requested attorney fees be dismissed. Thank you.
Ms. Anderson.
No one was submitted frivolously. Anderson herself is no one, Ms. Anderson does not notify her own signature. That is part of becoming a notary. You take an oath and you send in your verified signature as a notary, that you will not notarize your own signature. When the candidate decided that she would notarize the same sheet costing the village of Sauk Village more money. And this will not be, really a decision with credit. This was the first decision to get an attorney. She will pay her own attorney. For as far as harassing, the candidate, this was not done in, to be harassment. This was done because I am a citizen of Sauk Village and I have a right to challenge the petition. Just like anyone else, you also have that right to challenge the petition. Furthermore, if you did send whatever state sent, I did not get it before, but that would be nothing new. Since this board has decided not to receive the candidate's daughter, I will assume that you will go in agreement and dismiss this particular case. I have no.
Mr. Sackler?
I have not.
Okay. Mr. Chair, I reviewed the objector's petition. There are 17 allegations, which contains 17 allegations in it. I'd like to address each of the allegations, and then at the end, you'll ask for a vote. Objector's allegations under 3 through 11 allege that the candidate owes money to the municipality, and therefore she's not ineligible and not qualified as a candidate, and should not have her name on the ballot for the consolidated election of April 4, 2017. She has cited the wrong law. She has relied on people for the Sinkus case, which stated that you cannot run for office if you have, you cannot run for office if you have a debt to the municipality. However, in 2013, the legislature changed that law and said that a person is not eligible to take the oath of office for a municipal office if that person owes money to the municipality or is in arrears. Okay? That does not affect their eligibility to be on the ballot, only to take the oath of office once elected. Now, the laws, so the motion objection is not valid. There are no valid factual allegations that, even if true, would support a finding that the candidate was in arrears. And there are no ascertainable amounts. And per the circuit court case of Donahue, a non-reimbursed personal use of town resources is not tangible evidence, and it does not make an indebtedness due to the municipality. Okay? And you must have tangible evidence, not abstract, which is dependent on speculation and allegation unsubstantiated. Allegation number 12 states that the name of the candidate on the statement of candidacy is inconsistent with the rest of the document. I'd like to draw the board's attention to exhibit number G, which is the statement of candidacy, which she states her name to be Deborah Debbie Williams. And if you look at group exhibit number H, which is on the next page, she also states that her name is Deborah Debbie Williams. There are no allegations that this is a violation of the election code. 10-5.1 of the election code states that a candidate may designate her name on nominating papers. If this was any different, with their given names, their initials, or a nickname that a person is known by, or a combination thereof. And it may be used in addition to the candidate's surname. Therefore, the use by the candidate of the name of Deborah Debbie Williams is not a violation at all of the election code. Allegations number 13 through 16 are allegations regarding the notary. Okay, the allegations specifically are that a notary cannot notarize a petition that the notary is doing, that, and number 14 and 15 are that the notary cannot, or that you cannot notarize your own petition, that Ms. Williams could not notarize her own petition. And that number 16 is that on sheets 1, 2, 3, and 4 were all notarized on the same date and by the same notary who signed the petition. Okay. In regards to our legal opinion, the Chicago Election Board has uniformly held that nominating petitions cannot be invalidated solely because a notary was also an elector. A candidate may notarize his or her own petition sheets that have been circulated by another person. Because the notary in question is administering oaths to the circulator, there is no legal basis for the notary to be disqualified from also signing one of the petition sheets. In regards to allegation number 17, there's numerous allegations here, but it appears that there's really no substantive allegations or objections. What in number 17, the objector simply objects to numerous people. She objects to David Hanks, to Deborah Williams, to Rosie Williams, to Trustee Burgess, to Edward Myers, Edward Myers objects to Linda Washington House, objects to the law firm of Oldesman and Sir, but then states they have no objections to certain other trustees. Okay, this violates, there's no allegations in this objection, okay? This violates section 10-8 of the election code, which states that the objections, that the function of the board is to determine whether the nominating papers are valid. So allegations of political bias or speculation are misplaced. Political bias and speculation are not the basis for the allegation. Therefore, based on that, Mr. Chair, it would be proper at this time for a motion to grant the motion to strike and dismiss the objectors.
Ask for a motion to strike and dismiss the objector's position. Is there a motion to approve? Motion, is there a second? Second. Trustee Burgess, please call the roll.
Mayor Hanks,
Yes.
Trustee Williams-Bag,
Yes.
Trustee Burgess, no.
Motion carries.
Also, Mr. Chair, at this time, it would be proper to make a motion. I don't find at this time any basis for attorney's fees. There would be a motion to deny attorney's fees to the candidate at this time.
I ask for a motion to deny attorney fees to the candidate at this time. So we have a motion to deny their request. Is there a motion for this?
So move.
Second. Trustee Burgess, please call.
Mayor Hanks,
Yes.
Trustee Williams-Bag, Trustee Burgess, yes.
Motion carries.
With that, all matters before the electoral board have been asked for a motion.
I ask for a motion to adjourn.
So,
Got a motion, is there a second?
Second.
Trustee Burgess, please call the roll.
Mayor Hanks,
Yes.
Trustee Williams-Bag,
yes.
Trustee Burgess, yes.
I'm sorry, Mr. Chair. We do need to recess this to another date so that we can render the decision. May I suggest either next Monday evening or whenever it's convenient for the parties? I'm sorry, we need a motion.
I need a motion to reopen the hearing.
So moved.
I
Second.
got a motion and a second. Trustee Burgess, please call the roll.
Mayor Hanks,
Yes.
Trustee Williams-Bag,
Yes.
Trustee Burgess, yes.
All right, so we're gonna ask for a recess. Now, you know,
If I may make one suggestion, in other similar proceedings, both parties have waived the formal in-person service of the decision, instead of having that written decision being served via email, whatever method is best chosen by the parties, which makes it just easier. Any party is going to seek corporately in review of this. Just make it kind of easier so not everyone has to come back, but it's just a suggestion I figured I would make for free.
So, Mr. Sackler, do you waive your, you and your client's appearance at the signing of the order?
We do.
Ms. Anderson? Would you like to be here? Yeah, present, okay. And, Mr. Sackler, is that okay if we use your email?
That's fine, or I will.
So we need to determine a date that is convenient for all parties to be able to present the order of electoral. Where we need this to be. Right. Monday,
What time does that do? Have something to do on Monday? What time? 6:30 until. You just want to sign, correct? Okay.
right. They're rendering the opinion of
You don't have to vote on anything. do you?
Is the building open on Monday?
Oh,
No, it's Martin Luther King's. Martin Luther King. Yeah, no, the building's not open, but it's not open now. Yeah. That's fine with me. I mean, because the building's not open now, we just opened it. I mean, it's just going to be. Okay.
Is that okay with you, Ms. Anderson? Tuesday at 6 o'clock? I'm sorry, did you say Tuesday?
Yes.
Yeah, okay.
So I ask for a motion to recess until next Tuesday, which is January, what is it? January 17th at 6 p.m. here at the Village Hall. Ask for a motion to recess. Get a motion in a second. All in favor, say aye. Aye. Motion carries.